Hey everybody, how's it going? Welcome back to Copper Jacket TV. So I think we all understand there's some pretty dumb laws out there, but some are just dumber than others. Case in point, a federal judge just upheld a ban on laser aiming devices. You guys are going to want to check this out. Let's talk about it. Now, real quick before we get started, if you're like me and you believe firmly in defending yourself and your loved ones, whether you're in the home or outside the home, you need to do what I did and sign up for attorneys on retainer. I mean, let's face it, not all self-defense incidents are clear-cut. If there is even a small question about whether or not what you did is right, there's a good chance that you're gonna end up in handcuffs and you're gonna be taken to jail. And you're gonna need somebody that's gonna be there for you to defend you. And that doesn't come from some pencil pusher in an insurance company. You need attorneys on retainer. If an incident pops up, you call attorneys on retainer, an attorney giving you instant client privilege will pick up the phone. They will guide you through things, they will be there to represent you, and they will take care of you all the way through court. Now, if you're interested in attorneys on retainer, go ahead and check out the link down in the description box. There is also a discount code, which is CJTV. That'll save you $50 off sign up. Okay, so let's go ahead and talk about what's going on here. So like I said in the beginning, a federal judge has just upheld a ban on laser aiming devices. Now, try and keep in mind, these are just simple green or red dots that help you aim. That's all they do. But this judge cited that they were an extreme danger to law enforcement and also not protected by the Constitution. So let's talk about this case. So this story comes to us courtesy of the United States District Court, Northern District of, no surprise, Illinois. And this is the Second Amendment Arms and Joseph Franzese v. City of Chicago. And this challenges Chicago's outright ban on laser aiming devices, and this is a ban that's been around for quite some time now. Now, the plaintiffs in this case challenged the city ordinance, saying that not only did it injure them financially, but it also violated their Second Amendment constitutional rights. Well, it turns out that the judge considered otherwise and obviously gave the summary judgment to the city of Chicago. So in doing so, this is what the judge says about the constitutionality of these sites, where he says, Count 3 challenges the constitutionality of the laser sight ordinance under the Second Amendment. The Second Amendment recognizes an individual's right to keep and bear arms, but, right, there's always a but. You have a right to keep and bear arms, but like most rights, the right secured by the Second Amendment is not unlimited. And then they cite Heller. The Supreme Court set out a two-part test to determine whether laws run afoul of the Second Amendment in Bruin. Both Supreme Court decisions and historical sources indicate that the arms the Second Amendment is talking about are weapons in common use for self-defense. The Supreme Court noted in Heller that founding-era dictionaries defined arms as weapons of offense or armor of defense, and anything that a man wears for his defense or takes into his hands or uses in wrath to cast or strike at another. Defendants contend that plaintiffs' challenge to the laser sight ordinance fails at the first Bruin step because laser sights are not arms within the meaning of the plain text of the Second Amendment, but rather mere firearm accessories. Because a laser sight itself cannot be used to inflict offensive injury or used as defensive armor, it is not a weapon of offense or armor of defense, which I call absolute BS. Because absolutely, when a laser is pointed at you, it can be used as defense on its own. If you've ever gotten one kind of in your eye there, or somebody's pointing one in your eye, it sucks. Let me tell you, you don't want to be looking straight into it. Defendants argue that laser sights are akin to firearm silencers, which courts have consistently held do not constitute arms under the Second Amendment because they are accessories rather than weapons themselves. Now, try and keep in mind that this is the same city and state that said that you could ban magazines that could hold more than their specific number of rounds, a number that they determined, because anything that could hold more than the number of rounds that they chose is just an accessory and not necessary. It can still work with something that holds only 1 or 2 or 3 or 5 or 10, so you don't need to worry about anything more than that. Anything over that is instantly an accessory, and that's what they're saying here. Is it considered an arm? I believe absolutely yes, it is considered an arm. It is something that you hold in your hand for either offense or defense. It can be used as a deterrent. It can be used for multiple reasons, but the biggest thing that we have here is that it is used for accuracy, to try and make sure that nobody else, no bystander or anybody else, gets caught up in the incident. Anytime that you can increase your accuracy, you're talking about a good thing, but they don't care about that. They just care that they limit what you have, the amount of what you have, or the things that you're able to use, and it's all about that. That's all there is to it. They just want to limit your access to the greatest degree possible, that they can still use this type of an argument, basically saying that it doesn't implicate the Constitution at all, and therefore the city is allowed to ban whatever they want. And they've been using that argument quite a bit, right? I love how they always say, but. Oh, you have a right to keep and bear arms, but it's not unlimited, but the city can do this. That's how it always goes in these arguments. So as of right now, the summary judgment was granted to the defendants in the city of Chicago, and the ordinance still stands. Now, this ordinance applies to anything that is either attached or comes pre-built. Now, if it comes pre-built in the firearm, that means that sometimes you're not able to take it out. That's just the way that it's initially designed, and that's the end of it right there. So essentially, this does ban some firearms in Chicago. They wouldn't be allowed to come in because they're pre-built with that assisted aiming device. So that's basically what this boils down to. Yes, it does ban arms. It does ban that device, which just assists in aiming. It is absolutely ridiculous, but you all know why they're doing it. It's just all about control. So I wanted to let you guys know about that. I want to thank you very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.